Okay, I think we're live. All right. Good afternoon, everybody, and thank you for joining me for this session. And today's topic is subcontractor versus employee. This is the first of a double series dealing with employment-based issues. The next session will be on the 21st of June, and on that day I will deal with the issue of what is a casual employee. But as I mentioned today, we're dealing with the subcontractor and employee composite. So, to the usual things. The information contained in this presentation, both visual and oral, is provided for informational purposes only and should not be construed as legal advice on any matter. All right, usual story. Who is Bailiwick? Bailiwick is a specialist firm. We deal predominantly in agribusiness and tourism industries, and we deal with all manner of legal issues across those two primary industries, particularly in relation to commercial contractual issues, corporate issues, property law issues, anything transactional. We do not deal with criminal law, but we will actually nowadays with property disputes in family law. So that's Bailiwick Legal. Okay, today, what is a subcontractor? There's a bit of terminology context here too. Often people refer to this issue as a subcontractor. Sometimes they'll refer to it as a contractor. For today's purposes, we'll probably stick with subcontractor. That's the perhaps more predominant term that people are familiar with, distinguishing a subcontractor, that term, versus employee. So what is and what does distinguish the subcontractor from the employee? Well, hopefully we'll get to that today. In the agri sector, as in many other industries, and construction and transport industries come to mind easily when we're talking about some subcontract relationships. So engaging a person on a subcontract basis has been used within the agri sector and in tourism too, for that matter. The underlying philosophy is to try and remove liability. Liability lies in relation to a lot of things: entitlements to minimum wages, entitlements to minimum leave benefits such as annual leave and sick leave benefits. Removal from regime is quite an important underlying philosophy reason to engage subcontractors versus an employee. It also morphs into the need, or I should say reducing the liability to make occupational superannuation contributions. We'll also look to remove liability under the safety laws, and to remove any context of workers' compensation. In my view, there's a fair bit of illusory underlying all that, because when you get to superannuation, for instance, workers' compensation and safety, a lot of the time it is pointless to try and remove liability by engaging a subcontractor, because if the subcontractor is, say, for occupational superannuation contributions, earning 80% of their income through your business, they're more than likely going to be deemed an employee under the occupational super laws anyway. So there's no benefit. In the context of safety, again, on sites, and with the new laws coming into play round about mid-year this year, we were told, there's new state laws dealing with safety. well, it's not really going to matter whether someone's a subcontractor or employee on a particular work site. They're all going to be covered by at least one entity, or sometimes several entities might have a liability to cover particular people on a work site. I probably can't stress enough in this area that the courts are literally littered with cases where supposed subcontractors have pressed claims on the basis that that person was, at law, an employee. And what people sort of don't seem to understand a lot in this area as well is that in this area there are perhaps two somewhat uncommon concepts, if you like, or tenements of law that help determine the answer to the question as to what an employee is versus a subcontractor. And those two things are, somewhat strangely, in some respects, the courts don't care what the parties might call themselves. Often we will find, as solicitors looking at contracts, we'll find a contract where the parties expressly say this is a subcontract relationship, and the parties expressly deny that it's a relationship of subcontract, of partnership, of anything of that nature. Yet when it comes to determining the question of whether the person or a person, the party to that relationship, is an employee or subcontractor, the court's going to ignore that express determination agreed to, and it then looks to the totality of the relationship. And coming to the second point, it looks at post-contractual conduct. Now that, in legal terms, is a little sort of unusual, to look at post-contractual activity and conduct to determine the flavour of the contract that the parties have actually entered into. So just something to bear in mind in relation to those two issues. So, the crunch. How do you tell the difference? What is a subcontractor as against an employee? And I'm here today to tell you that nothing is black and white. So this is what people refer to often as a grey area of law. It is grey because someone can look at a particular set of circumstances and reach a particular conclusion. Someone else might reach a different conclusion. The courts have, in that context, come up with some factors. I'll say factors that the courts then look to try and determine the flavour of that relationship. Those factors, fall within two broad concepts, often referred to as the control test or the multifactorial test. The factors a court will look to, and this is not in any level of importance, but I'll go through probably 7 or 8 particular factors that the court will consider on the question of whether the person is an employee or a subcontractor. And the first of those is this concept of control. If, as the primary person engaging, so I'll refer to this person as the engagor. If the engagor has little control over the manner in which the person who has been engaged is doing the work, then it's more likely, leaving out any other factors, it's more likely that the person will be a subcontractor. So the more control that is exerted over the manner of doing the work, direction, where the work is to be performed, and particularly sort of how the work is to be performed, the more control being exerted over those things, the more likely the relationship will be one of employment rather than subcontract. So, the corollary of that is if the individual can choose to accept work or reject work, can choose where the work is to be performed, has the ability to do the work in whatever manner that they want to do the work, can delegate the work to someone else, then the elements of control are substantially reduced, such that it's more likely that person would be categorised at law as a subcontractor. So control as a particular factor and as a test is very, very important in the context of determining whether someone's an employee or a contractor. Payment of tax and superannuation are two other factors a court will look at, but by and large most of the authorities now say that those two factors are ambivalent, right? And that's really based on the proposition that, well, if you're earning an income, you're going to pay tax, whether that tax is through your individual exertion and it becomes a personal tax obligation, doesn't really matter. So the courts really just say, well, that's a bit ambivalent. We don't care necessarily as to how tax is paid, whether it's through an invoice and GST is paid, or whether it's through PAYG contributions. A bit ambivalent, neither here nor there in the context of a factor. How someone is paid, though, perhaps that's the wrong way of phrasing it. The basis upon which payment is made is a relevant factor. And so typically what we see in a subcontract agreement, and I'll put that in quotes because for the example I'm going to give, it's not necessarily going to be a subcontract agreement, and that is where payment is based on hours worked, and then an hourly rate is attached to that. If you as the engagor are in receipt of an invoice from a person you've engaged, and that invoice simply racks up the hours worked per week or per month, times it by an hourly rate, gives a figure, takes GST on, adds GST on and gives you a result. Well, what are you actually paying for there? You're paying for the person's labour, which sort of connotes you've got control over what that person is doing and where and when. And the payment on an hourly rate like that is more akin to a payment for an employee. So that's a big factor, the basis upon which payment is made. Take, for example, the sort of extreme to that, opposite to that, is where you're paying for a task to be performed. So let's say you've got someone engaged and you want them to construct a silo to store grain. I know you'd go and buy it, but let's say, for argument's sake, that you want someone to come and build you a silo. If you pay that person an hourly rate based on the number of hours it takes that person to build the silo, more akin to an employment relationship. But if you pay that person a fixed sum for the construction of the silo and it's payment at the end of the work, it's much more akin to a subcontract relationship. And that's a pretty good example of why how someone is paid and the basis for that payment is a relevant issue. Another factor is insurance. So if your subcontractor has their own workers' compensation insurance, has their own public liability insurance, probably more importantly, then that's a good indicator that it's a subcontract relationship. Workers' compensation insurance by itself, again, is one of those ambivalent ones. Every person, well, I say every business, regardless of whether they have employees or not, must have, at law, workers' comp insurance. And that insurance is necessary regardless of whether they're engaging employees or subcontractors. So the obligation to disclose the payments made to employees and subcontractors is part of the legislative requirements, and so workers' compensation as a factor becomes, as I said, ambivalent. It's neither here nor there. So another important factor is what's referred to as integration. Now, this is perhaps not so easy to define in a very generic summary context. It's the question of whether the person is actually integrated into your business. Maybe the question is to be posed of who is that person working for? If the person is working predominantly to increase your business and your goodwill, then they're more likely to be integrated in your business and therefore an employee. On the other hand, if they are working for themselves, they have a business, they're developing goodwill in that business, then it's much more likely that the court will say, well, there's no integration and they're a subcontractor. And this is quite an important issue because the concept of the true subcontractor is someone that is truly at law working for themselves. And when you think about that, you can understand what that means in your own context. So if you're running a farm, you have certain assets and you are operating a business for the benefit, or you're using those assets to operate the business to produce profit for yourselves. And in the context of people coming to work for you, look at it in the same way. What are they bringing to the table by way of assets? Are there any assets coming with them? Are they actually operating a business for their own benefit to increase profit for themselves? And increasing profit, they're increasing goodwill for themselves. If you cannot determine that someone's increasing goodwill, it's going to pretty much be that they're an employee. But if someone is generating and operating a business and generating the prospect of goodwill out of that business, it's much more likely that they'll be determined to be a subcontractor. So a couple of other factors that really fall within that integration context, as well as other independent factors on the multifactorial test and the control test, are working hours, the ability to delegate work, and the location of work. In the context of working hours, if the person can choose their own hours and not have to be told what hours to work, whether they're fixed, Monday to Friday, sort of 8 a.m. to 6 p.m. If you're having to tell someone that they're their working hours, well, it's more like an employment situation than a subcontracted situation. And let's flip it back to the building of the silo. So if you're telling the person building the silo that they can only work between 8 and 6 every day, and that it's only Monday to Friday, and you're paying them on an hourly rate, that's an employment situation. But if you're engaging that person to say, go and build that silo, I want it finished, say, in 6 weeks' time, I don't care what hours you work, but I'm going to pay you this lump sum at the end. That's an easy way to explain the notion of working hours as well. The other factor I mentioned amongst these three then was the ability to delegate. And similarly, using that silo for an example, if you engage that person and you say, I want the silo built, I want it done in 6 weeks, I don't care what hours you work whatever hours you need to, I don't care who you get to help you with it, I'm going to pay you this lump sum at the end, then again, much more likely to be a subcontractor situation. To work Monday to Friday, it's 8 to 6, 8 a.m. to 6 p.m. to delegate to anyone else, and the work's got to be done here, coming to the location of work, then much more likely to be an employee. And I mentioned the third factor there, I alluded to earlier, the location of work. Again, that silo situation, you could be saying to that person, I want the silo built in 6 weeks, it's got to be delivered here. Right? It's delivered to your farm. So you're not making any rules and you're not taking any control measures over where the work is to be performed. And in those circumstances, the court's more likely to say that it's a subcontract. Another couple of factors that arise to relate to equipment. I mentioned earlier about you running your farm business, you're using particular assets to do that. And that's a key factor too. What assets does that person bring to the job, the task? Does the person have their own vehicle? Does the person have their own tools and equipment necessary to perform the task? Perhaps an easy example of this is, say, an electrical contractor. You engage an electrical contractor, you want some RCDs put in the shed. So you call your local contractor, they come out and do the job. They have their own van, they have their own equipment, they are told what's needed, but they're not told how the work is to be done or necessarily the time frame to be done in, or who is to do the work. Clearly a subcontract situation. Versus the opposite to that, where you tell someone, well, you're one of your employees, go and fix this item in the shed. I'm not going to use electricity as an example there, because you're not going to tell your employee to fix something electric unless they're actually qualified. So just be wary of that. So if the person has their own equipment, they have their own assets, and they're using those assets as a business to generate profit and goodwill, much more likely to be a subcontract situation. Another factor which has loomed large in a few cases, some pretty old cases too actually, is the concept of wearing a uniform. Now, this is one factor that has arisen, as I said, in some cases. There's a very well-known case in WA where the wearing of a uniform really sort of broke the case apart, and the determination was because they wore the uniform, amongst other things, the person was an employee. Wearing a uniform per se is not necessarily indicative of employment or subcontract by itself. If it is a requirement amongst the other factors that point to an employment relationship, it will assist the court to determine the employment relationship if it is compulsory to wear a uniform. So just be wary of that. There are a lot of companies out there now that brand shirts, brand jackets, brand caps, and they require their employees typically to wear those things. But what I'm saying is subcontractors could be requested or required to wear those particular items of uniform as well. And that doesn't necessarily mean that they're an employee. You need to look at all the other factors. Okay. The last factor I'm going to deal with is the nature of the labour being engaged. And perhaps the electrical contractor is a good example here, because it's a particular skill. It's a particular skill that requires a license. And typically your employee is not going to have that license. Now, clearly we can distinguish this in the context of mechanical issues, because if you engage a mechanic, you want the mechanic to be qualified. I would hazard a guess that outside some of the bigger entities in the mining sector and maybe construction, that you're not going to be engaging a employee that's a licensed electrician. You might, but I think that'd be pretty uncommon. So another factor that I'm alluding to there is the qualifications the person brings. If the person doesn't have any particular qualification and needs direction as to what work is to be performed, let's just take the example of a general farm hand. You're telling the person what's required, you're giving them direction as to how it might be done. From time to time, you'll go through an induction, all those sorts of things. More likely to be an employee. But if you engage someone like the electrical contractor that comes in, you have really no control over how that job is undertaken. It's undertaken, invoice is rendered at the end for the work that's undertaken, and you pay that, and that is a subcontract arrangement. So I could run through a few recent cases, but by and large I think the cases that have really captured attention, I think amongst employment lawyers and the profession at the moment, sort of human resource area, the sort of outliers. They're the Uber Eats people, they're the courier riders, they're the Deliveroo riders. You know, they're a different sort of set of people which don't necessarily fit within the traditional model of whether they're an employee or employer. And I say they don't really fit within that traditional model because in the UK they've been referred to as a gig economy worker. And they, in the UK cases, the case law has really come to the point where, yeah, they are a different beast. They're not a worker, an employee in the traditional sense. They're not a subcontractor necessarily either. They sort of fit somewhere in the middle. In Australia, we haven't got to that point yet. In the context of Uber Eats drivers, there was a decision of the Fair Work Commission full bench last year which found that those drivers were independent contractors. And there were a few factors alive there. They had their own vehicles, they were actually carrying on business, they could choose when to work, what hours they wanted to work, and whilst they may not necessarily have been building goodwill in themselves, one suspects that they probably were. If you've caught Uber yourself, or Uber Eats or Uber taxis, you may have developed a rapport with a particular driver. I know, in the context of taxi drivers historically, you generate a rapport with a particular driver and you would give them a call whenever you needed to go somewhere. This is no sort of different to that. In the context of Uber Eats, similar situation. So, however, the full bench, as I said, didn't deal with this concept of gig economy worker, but slotted these drivers into the independent contractor realm. Another case quite recently, that is last month, Deliveroo riders, I should say, were, in one case, the person was found to actually be an employee, notwithstanding that the other factors, that they could work whenever they like and brought their own tools to the job. The Fair Work Commission found that the person was an employee for the purposes of an unfair dismissal claim. Now, Deliveroo have indicated that they're going to appeal that decision. I fully expect them to appeal that decision. I don't think at this stage we can take anything from that decision, because it's a single commission decision and it's, on the face of it, actually inconsistent with last year's Uber Eats decision. So we'll maybe visit that one towards the end of this year, once the full bench has had a look at it and made a decision as well. The point I'm making, though, in the context of this gig economy worker, is that this concept of employee subcontractor is probably, in Australian law, going to be enveloped with a third option, if you like, and that is a gig economy worker. In the UK, they have established a minimum wage and a minimum leave entitlement for those people, and it's foreseeable at some future point in Australian law that minimum conditions will be legislated for these types of workers as well, because in many respects they don't fall within the traditional concept of employee and subcontractor. Okay, so just to sort of recap, the distinction between an employee and a subcontractor is not necessarily an easy one to identify. The courts often struggle with the identification, which is why the courts have developed this multifactorial test, including the quite important issue of control. I think I'll leave it there. If people have any questions or would like further advice in relation to this particular issue, please feel free to send those through on Facebook or email me at phil@bailiwicklegal.com.au or telephone me 0427 783 168. We try to provide our advice based on common sense, principles, business experience, strategy, and the practical realities of actually running your business and life. We do have experienced people within the firm across commercial property, employment and succession law issues, and we like to assist clients to achieve the best outcome that they possibly can. We do take a personal approach, and we like to try and source solutions based on practical outcomes. So feel free to reach out to me. We do 30-minute consultations for free, so please give me a call and hopefully we can put your mind at rest if you have any issues. So keep safe and well. Thank you.